going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Happy Tuesday. You guys want to watch some court? I want to watch some court. Let's watch some court. I've got a bunch of stuff tonight. The theme of the night is defendants talking back to the judge, or defendants just talking too much. Either way, talking back, talking too much. That's the theme of the night. So got a bunch of those kind of clips. We're going to start with Judge, is it Collier? Yeah, Collier, down in Florida. Got a Judge DiSanto clip that I think I've seen on at least 2 other channels, so you guys may have seen that one, but it's good. It's really good, so I could not share it. And then I've got a bunch of small clips. Yeah, that's what we got tonight. All right, before I hit the play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. 1 second. Can't say let's go yet. Super on time fee from Mary Smith. Thank you so much, Mary. I appreciate the super chat and the super on time fee. I appreciate it. Thank you. All right, let's go.
Doing this morning?
I'm blessed. Yourself?
I'm blessed as well. Thank you.
Oh, also real quick, I want to shout out Lucy for letting me know this was going on. Yeah, I'll just say that. I don't need an explanation. Lucy told me about this case, and it's good. So thank you, Lucy.
His application get approved.
And since we're just going to pause it 10 times at the start of the video, Heather!
Judge, Mr. Wesley's here for an arraignment on a charge of introducing contraband 24-219. Madam Clerk said that I qualified, or he qualifies, so
Okay.
my plan is to enter a not guilty plea and ask the case be set for the 9/9. If you'll let me finish, sir, you can have all the time you need to talk to him. Let me take care of what I got to take care of. Judge, my plan would be to enter a not guilty plea on Mr. Wesley's behalf and ask for the 9/9 court date. I can also tell the court that I represented the co-defendant who was involved in this case when her case came through. So I'm pretty confident there's going to be a conflict. I'll need to review it, but I'm pretty sure there's going to be a conflict with me representing Mr. Wesley after today, and I will certify that conflict to Mr. Sims.
Yes, sir. Yes, sir, Mr. Wesley.
How you doing today, Your Honor? Sir, I wrote a letter for you. And if it's okay, I have a couple of documents. I was out on bond.
Okay.
And I was on mental health court. I'm diagnosed paranoid schizophrenic, self-mutilated, and audible and visual hallucinations. I'm on 4 years mental health court. Well, I'm on a year mental health court, 3 years felony supervision in Okaloosa County.
Okay.
I caught a failure to appear. I'm the one that came late that one time in April, I believe. I had my court date and I was like 2 hours late, but I came from 3 hours away. My ride was late.
Yes, sir.
And you had them put out a warrant, but you withdrew the warrant.
Yes, sir.
Because you see I came. Okay, what happened on this incident, they gave my dad 90 days in the life term. They placed him in hospice. He's in South Florida. April 1st, I was evicted from the residence I was living in. Mind you, I just got out of prison December 14th. Point is, a lot of things crumbled for me, sir. I was incarcerated when this warrant for a failure to appear got put out. And right now, I have a business. I'm a mobile barber.
Yes,
I'm
sir.
a 24-hour mobile barber. I'm on 4 years probation right now. Okaloosa County is awaiting me right now. There's a 6-person staff that, because of my attentiveness, because of my compliance, because of me doing what I was supposed to, because you had granted me, they reinstated my bond last time when they initially put me on mental health court. So now when I was just sanctioned, because I collapsed, for the new law charges, they said, well, because he was already doing what he was supposed to, we're going to leave him in the program. So the resultant of the
KCC raid. Thank you for the raid, KCC. I appreciate it. Welcome to all the raiders. Thank you. You know what? I was going to wait till the end of this clip to catch up on the super chats, but I'll just do it now since I'm paused. Mary Smith. Nope. Super on time for you. I already said thank you to that one. Oops. Hold on. I don't know what I'm doing. Mary Smith. Vic's super on time fee. Thank you so much. I appreciate it, Mary and Vic. Thank you for being super on time as well. Alex, good to see you. Hope everyone has a great night, Fee. You know what? Yeah, I agree with that one too. Thank you, Alex and Vic, not battling Mary Smith tonight, Fee. All right. I think I like the game with the fees. I'm not charging the fees, just so you know, but you can keep giving them to me. That we can play that game all night long. But thank you guys so much for the super chats. Let's go.
Disposition of the case in Okaloosa as of right now was reinstate my mental health court.
Yes, sir.
But during that time I was sitting in Okaloosa County, it was April 30th until 7/3/25 till I got here. But that wound up giving me a failure to appear. I'm saying all this to, well, I'll read a letter to you. I'm just giving you a brief, and if you don't mind, if you can just look over this real quick.
You can
Please.
tell me, you can.
That's just documents of my business. I wanted you to get a picture of what I actually. Honorable Judge Collier, blessings to you, sir. Writing brief description of the events that led to my failure to appear for my existing case here in Gulf County, with faith and intent to please your court and Lord's willing be released today. In the latter part of March 2025, my father was unfortunately placed in hospice care and given a 90-day end of life term. Secondly, following that news on April 1st, 2025, my girlfriend and I, along with my 6-year-old stepdaughter, were evicted and literally rendered homeless. Honestly, within days, sleeping and surviving out of our SUV. Honestly, I became overwhelmed mentally. Currently diagnosed with paranoid schizophrenia, audible and visual hallucinations, and self-mutilated, I ultimately collapsed mentally, relapsed to drug use, attempting to self-medicate. Graciously, all these things came upon me during the time that I was given the opportunity to get much-needed treatment, care, and counseling through a sentence of mental health court probation in Okaloosa County. Ms. Susan and staff, having knowledge of me being compliant to mental health instructions before distresses arose, obeying all ordered stipulations given by both Bridgeway Behavioral Centers and contact instructions ordered by the probationary staff and oversee the participants in the program and are set in place for the defendants to heed and eventually succeed. Arrested on 4/30/2025 through 7/3/2025, the mentioned judicial staff involved with regulating this program and observing progress by the individuals made notice of my personal determination and diligence with keeping my appointments, registering, and biweekly required court proceedings. I was sanctioned, held for 2 months, and accepted back into the program with modifications made to satisfy the court staff. And thankfully restarted my 1-year mental health court probation, followed by 3 years felony probation. Having my diagnosis increase in severity over the years, I can humbly admit the program is a true blessing and positive alternative to incarceration, sir. In closing, respectfully, I did not willfully miss my court date of 5/6/2025 because of incarceration for mental health sanctioning. Again, my sincerest apologies for inconveniencing your courts. I pray that your honor will allow things to be considered on my present court date of 8/12/2025, henceforth based on the facts, to allow reinstatement of bond, order pretrial release, or allow a resolution of my case with concurrent probationary term, invoke some form of release on my behalf, allowing potential positive opposition to otherwise recidivism. Your Honor, this mental health program is much overdue, therefore wanted and needed in this particular point in my journey of my life right now. I humbly admit that years have passed with me in and out of prisons and relapse into drug addiction, attempting to mask the inevitable, being I am diagnosed with severe mental health issues and need help. Even if it's ordered via the judicial process, I am no less grateful. I currently have waiting for me a treatment referral that has been granted a hold at Bridgeway Adult Behavioral Treatment Center. They are awaiting resolution of Gulf County case or release. This treatment opportunity is a tremendous blessing given all that has transpired in these last few months, and I have absolute determination and diligence to make full self-growth, reaching success. I will take opportune advantage of this sentence, including proper evaluation, therapeutic counselors, prescribed needed medications, and proper consumption. Personally establishing the peace to focus on much needed adult life requirements. Upon release, I will be registering for the licensed clinic. They'll be in Okaloosa County on September 19th. Therefore, I won't get no more suspended license.
Okay.
They clear your license, whatever you have holding against you that's keeping you from being able to acquire your license, they're gonna actually clear it. I haven't had a legit license since I was 17. I'll be 43 years old, Lord's willing. I'll be 43 years old, October 28th, Lord's willing. I ain't had a legit license. This is my opportunity to be able to get my license and all.
You said that's
Lord,
October?
That my birthday is October, but they have the license clinic September.
Okay.
Next month they have the license clinic coming to Okaloosa County.
We have a plea offer in this case, Mr. Patterson?
I wasn't finished real quick.
Oh,
if you don't mind.
no,
sir.
I
Sorry
don't mind
about
at
that.
all. You paused. I thought you were finished.
Through the program, I was.
Yeah, that we were hoping he was finished. He wrote a letter, but he didn't write a letter. He wrote an autobiography. Yeah, I mean he's going into his entire life story right now.
Also be applying for proper health insurance needed to maintain my medications. Also included after sanctions implemented weekly, they added in that I must take weekly Narcotics Anonymous and Alcoholics Anonymous twice weekly and urinalysis weekly to even more assist with sobriety and ultimately graduating. Judge Collier, thank you. God bless you. God bless America.
Thank you. You're asking,
I'm asking if I can have my bond reinstated today, sir. I like I said, I'm not gonna miss court. If I miss your court, if they have to work out a deal or whatever, if I miss your court, that violates my
After all of that, the judge just said, "What are you asking for?" Oh man.
paper over there. I'm not gonna miss court. I came to court. I'm 3 hours away, but I have people that help me. Like I said, the only reason I missed your court then, you had actually made an announcement at the end. You said, "Is there anybody else I haven't seen?" And I was in the back, and I said, "Sir, you haven't called me." And I said, and you said, "Oh, well, Mr. Wesley, I've already put out a warrant on you." I said, "Well, sir, I've been calling the clerk of court. I've been calling the treasurer. I've been letting everybody know this is Roger D. Wesley Jr. I'm on my way. I'm coming from Okaloosa County. I was in traffic. My ride was late, but I'm coming." And I showed up late, and I was the last one you seen. You said, "Mr. Wesley, I'm gonna withdraw your warrant. See you on May 6th. But May 6th, like I said, I was sanctioned because of the new law, and they had me in jail. So that's why I got the failure to appeal. So if I could be released today, sir, on pretrial or whatever it is, I'm gonna be in court. But right now, like my diagnosis is bad being in that open bay dorm. Like it's bad. My last 6 months in prison, last time I got taken out of an open bay dorm, placed behind the door.
are you on your medication?
Sir?
Are you taking your medication that's prescribed?
I'm not taking medication here because I haven't started. I had to see the psych doctor so that they can. I'm on serious medication. I take Haldol, Cogentin. I take serious stuff. So I had to I had to have another visit with the actual psych doctor so they can revise what medications I was on because I've been on so many. I was on 2,000 milligrams of Depakote. That's the highest amount you can give any human being of Depakote. I was taking 2,000 milligrams a day. I'm diagnosed paranoid, schizophrenic. I'm very intelligent, but when it comes to my mental, so I done cut myself 100 sometimes, like literally. It's not a joke. I ain't saying I ain't suicidal. I'm just saying, like right now, this program, Miss Susan and that team, they fought for me to stay in it. I've actually been sending messages to Miss Susan, and I sent her a message yesterday and said, "Miss Susan, I go to court on the 12th. If I'm released today, I will be in mental health court in Okaloosa County tomorrow."
I'm not sure what the plea offer is. If you're asking me to listen, the failure to appear, I agree with you, was not willful, but you picked up new charges,
Yes,
which
sir.
violated conditions of your bond. The state filed a motion to revoke your bond. I granted the state's motion to revoke your bond. So, I mean, you're going to be held without
I understand.
bond. Mr. Patterson?
Judge, I was just going to interject. Mr. Wesley scores 48 months in the Department of Corrections on this case, and that's currently y'all.
All right.
So what about the probate? We can't run the probation?
I have absolutely no idea about anything else he's talking about from Okaloosa County as we sit here right now. But that's the plea offer.
Absolutely.
Based off the score sheet.
All right, Mr. Wesley, let Mr. Hill and Mr. Patterson do some work on your behalf, okay? And we'll bring you back September 9th at 1:30.
Thank you.
Yes, sir. Thank you.
But he said he said he won't be representing me then though.
He said he's going to go back and determine whether or not he has a conflict. If he does, then
But the codefendant in the case had got 5 years probation.
okay. That's something that they'll look into, okay?
Yes, sir. You got the other paper, are you on?
Yes, sir. We put
Thank you.
everything will be filed with the clerk.
You got to check all those, yes or no, however they're applicable to your situation.
All right, I think that's it. All right, that was just how we're going to start the night. The next one is where the fireworks are. Before we do that, though, Michael, thank you so much for the 13 months. That is awesome. 13, thank you. And then Legal Fiction with the 19. Thank you so much, Legal. And Jen with the 10 gifted memberships. Thank you so much, Jen. That's very generous of you. Welcome to the 10 new members. Thanks, Jen. That is awesome. All right. Next one. Next one is the Judge DiSanto case. I know OSG put it out. I saw it on someone else's channel too. I want to say maybe Mike played it. I can't remember. I think it might have been Mike, but I know it was at least on another channel. OSG did cover it. This one's good. It was good. This is what happens when, you're editing a video and you see other channels posted. It was like, well, I can't put it out as a video anymore, so I'm just gonna throw it into my live. So that's what this is. Judge DiSanto. This guy is dumb. He's actually, he's dumb. I'll just say that he's dumb. Let's go.
In the matter of Nelson Hauk, 241298.
Good morning, Your Honor. Your Honor, John Goldpaw, P. 30758 on behalf of Mr. Hauk.
All right, Mr. Hauk, your name for the record, please. You're muted.
Oh, I'm sorry. Nelson Hauk.
Okay, thank you. And thank you for dressing appropriately, at least from the shots up that we can see. So, two things. One, your client is here for sentencing on his plea to an amended charge of disorderly conduct. I don't see Kevin Hamilton or Jamie Tackett here. However, the court can still proceed in this manner.
That is correct, Your Honor.
And
this seems louder than normal though, but that doesn't help because the mic isn't that good. It's like you can hear it's like fuzzy. Sounds like she's talking to a tin can. It always does. But thank you so much for the super chat, Dr. JD. I do appreciate it.
there's also the request, we'll just handle this on the record as well, regarding use of marijuana while on bond. And counsel, as to the sentencing.
As to sentencing, Your Honor, you indicated use of marijuana while on bond. I'm not aware of that.
Well, so Mr. Hauk had submitted proof of a medical marijuana.
Oh, that's correct, Your Honor.
And he had one prior to the arraignment that expired, so then he renewed it during the arraignment or during bond phase. And so my thought was that we would chat about that today.
Oh, okay. I saw that in the, but I wasn't present at the original hearing. Fine, Your Honor. We've had an opportunity to review the pre-sentence report in this particular matter. Your Honor, this has been an ongoing matter. It's been a lengthy negotiations. This matter actually occurred back in September of 24. I reviewed the video of the arrest. I filed a request for the video of the incident, and we're informed that the actual video of his time at the McDonald's was no longer in existence. We've discussed his involvement in this matter and the reasons why this occurred. As to the general background information, as you can see, Mr. Hauk has not had an easy life. Some of it is of his own doing, some of it is because of the early stages that he went through, ended up with the being, excuse me, and I apologize, Your Honor. He's been diagnosed with behavioral problems, clinical depression. His parents never married, and he became a ward of the state at age 7. I'm sure the state did as best they could. However, as the court is well aware, that's not the best of all circumstances. He did complete high school. However, he did not graduate. and he received his GED. He also indicated that, in here, that he has a paralegal certification. Trust me, my discussions with Mr. Hauk, he's clearly learned a great deal during his paralegal training. He's indicated his health is decent. He's on parole, has been for approximately 3 years. His parole officer is aware of all that is going on in his life. I did not speak with the parole officer, but I did carry on some other conversations with Mr. Hauk regarding that. To be honest with you, Your Honor, and I know he wishes to make a statement, but as you can see from his statement, he was at McDonald's. He was there to pick up some food. That's why he was in the area. Things got out of hand. He felt that he was being mistreated. I guess one thing leads to another. And when you review the body cam, it's clear that when the officers arrive, he is attempting to tell them what really happened in there, asking, hey, I need my witnesses, and they're just saying, well, no, and they're just responding and making an arrest, whether, rightfully or not, but he was, and you can see that what occurred and what triggered the incident in McDonald's. And I'm not saying he's not taking responsibility, but in his mind at that time, regarding whose fault it was or whose fault it wasn't, and as you can see from his statement, the long story short is I was in the wrong and I split this. I think, Your Honor, that this all carried over. And so I know that the recommendation is for incarceration. He's had 3 children. He has a 4th on the way. I believe she's pregnant. I know she's pregnant, and she's due in about a month and a half. He is not employed at this point in time, though he is still going out and looking. As again, one of the things on his parole is, as he told me, for the 3.5 years, he hasn't violated. His probation officer has not found a reason to violate, which is good. And I'm not suggesting. In fact, he's told me that he does not believe that he'll be violated for parole on this one. However, Your Honor, I'm asking that the court place him on probation.
Empire Lady, thank you so much. 6 months, that's awesome, and I'm glad you're here. Thank you for the super chat as well, and your kind words. I do appreciate it. Also, Iggy, thank you so much for the 8 months. I appreciate it. 8 months, that is awesome. Is this Gold Paul? I think this is Gold Paul. He's trying. He's trying. We're not gonna mark him for lack of trying right now. But yeah, just wait.
He does have another matter that's in the Lansing Circuit Court. His parole officer is also aware of that. And as he's indicated to me, that's set for hearing, and they're aware of this matter as well. He's on probation not probation, but on bond out there. He's on a tether out there, and he's been in full compliance out there. I don't believe that incarceration at this time would be the appropriate remedy. He is the sole child care support. He's trying to get SSD. That's under appeal. And as he told me, what he's trying to do, Your Honor, is to, he also is attending mental health treatment, and he's trying to get better. He recognizes his past and recognizes that he cannot continue that way. And he's trying to move on. I don't believe that incarceration at this time would be beneficial to anyone.
Well, what would you suggest, counsel? Because the individual in this matter, well, first of all, the way that I review the facts of this case is that Mr. Houck was dissatisfied with the time it took for him to be served or to pick up a mobile order, whatever it may be. So he decided to then go behind the counter himself to get his food. Then proceeded, when an employee was attempting to prevent him from doing that, proceeded to assault that employee. Now, your client also, in addition to his lengthy criminal history going back to 2008, has a number of assaultive crimes. Currently on probation, on parole, and he's also out on bond on another matter prior to this matter.
That's in Lansing, yes. Yes, sir.
I understand that.
No, I'm just saying.
But for parole to not violate Mr. Houck based upon this incident and this behavior, and for bond violation to not be occurring, I'm not sure if it's occurring actually, I don't know if that occurred, but also for parole violation to not occur on the Lansing matter, I have serious concerns for the safety of the public and individuals in general, given Mr. Houck's tendencies for violent behavior. This was over a mobile order for food that Mr. Houck was tasked by his boss to go pick up. This matter was scheduled for jury trial, and quite frankly, the prosecutor at that time thought that it was in the best interest of justice to offer this matter, or this plea in this matter. And quite frankly, I don't see how I have a choice other than jail for Mr. Houck. Because the purpose of probation is to afford somebody an opportunity to learn from their behavior, fashion conditions to help them modify their behavior. I have zero rehabilitative conditions that I could offer to Mr. Houck. Zero. I have zero confidence that any of the conditions that I would typically put forward for somebody in a matter like this, that any of those conditions would be rehabilitative.
Well,
At all. Mr. Houck, I am flabbergasted that you thought that it was your right to go back behind a counter of a place of business that you are not employed. And then, when somebody attempts to stop you, you assault them.
Ma'am, can I speak? Are you asking me as far as opening the floor for me to speak?
Sure.
Okay, well, ma'am, I think you're misinformed on the incident that happened there. And that is why, if the video would have came out, it would have showed the true actions of what happened there, ma'am. And I don't know where you're getting the information of. I was upset about how long it took or anything like that. Ma'am, that is not accurate information at all. There is a police call. There was video evidence. You would have heard all these things if I'd have went to trial, ma'am. But the video was somehow lost. But 14 seconds of another video to show two heads bobbing in was found, which is a mind-blowing to me. And I'm flabbergasted that justice isn't thinking, where is the evidence? Why was not evidence preserved at the time of a crime that you said you seen me commit from a video image? So why was it not preserved? That is the flabbergasted part to me, ma'am, that you are condemning me in your head already off of facts that are not true. There's like no factual basis for what you're saying. Besides word.
I kept trying to figure out if he was saying that. I was like, is he leaving the L out of that word? I think he just learned a new word and he's using it as much as he can. And I don't think he's pronouncing it correctly. I mean, but hey, props to him. He knows a word that has a lot of syllables in it now. He just needs to add the L.
Word of mouth. and anyone can write down their version of the story. We, like, you know, ma'am, and I know, ma'am, there's 3 versions of every story, but one version doesn't lie, and that's video evidence, right? And somehow somebody scrubbed the video evidence because they didn't want the truth to come out, ma'am. So,
sir, pause just a moment. I don't know if anybody scrubbed any evidence or
the video evidence was never produced, ma'am.
Sir, if you'd like to make a statement that the video evidence isn't available or whatnot, you don't know what happened with the video evidence. I don't know what happened with the video evidence. I don't even get the ability to see the video evidence unless it's submitted pursuant to the rules of evidence. And since there was a plea in this matter, that never was
I would
an
love
issue.
to go to trial.
Excuse me. As far as where I'm getting some of that information, some of it's in your own statement, sir, regarding you were ignored for around 5 minutes. So that was in your own written statement.
Ma'am,
So
in my written statement, I confirmed that I stood in line waiting. I stopped a different worker, not even the worker I got into an altercation with, ma'am. I stopped a totally different worker and asked him a simple question of, hey, when does these numbers and I didn't say it with aggression. I didn't say it with irritation. I said, hey, can you please tell me when do these numbers transfer over to these numbers so I can get my order and go? I said, I already paid for the food. It's already done. And before he could even answer, the person who I got into the incident with came rushing over, intervened. What's going on here with an attitude? I didn't get an attitude back. I just explained the same thing to him, man. I showed him the picture I had. I showed him the screenshot I had that confirmed the order was already paid for, confirmed everything was done. I didn't even need to even come talk to nobody for real, man. All I had to do was be handed it back and go, right? So I didn't go in here looking for an incident, ma'am. I did not. This is not like a...
I didn't say you went in there looking for an incident.
No, but you said I'm in there violent prone, ma'am. You're trying to paint a picture in your words. You're trying to paint a picture of this big violent person. Ma'am, do you know how long it's been since I've been accused of a violent crime besides this one? It's been years. I have been working on, yes, I've had a violent past. Yes, I've had a history. Ma'am, I was taken from by the state at the age of 7. I was raised in placement homes and lockup facilities. I was never given a chance at true life. I was given the chance at being a caged animal. So then when you ask me, am I prone to violence? Yes, sometimes I do have what I'm diagnosed with, explosive behavior, ma'am. And that's only when pushed. All my violent record I have is assault and batteries. All those are from being...
Yeah, I think this is the sentencing, though. So it doesn't really matter if he talks about his case at this point. He's already pled guilty. I think this is the sentencing. I believe it is, from what the defense attorney, what Gopal was saying at the beginning. But if you pled guilty, or even if you're accused of a violent crime, don't show aggression towards the judge. Don't do it. That's a bad look. That's a bad look.
Locked up facilities, fights in a lockup facility. None of those are from street altercations, being in the real world altercations, ma'am. So I am not violent prone like you think I am. I was in a cage situation with other violent people, and situations became violent. Not to allow myself to be a punching bag to other people. Yes, and because I did more damage, I got charged, ma'am. I can't help that.
Sir, your matter out of Utah in 2018.
Yeah, 2018. How long ago was that, ma'am? How long ago was that? 18. This is 20. We're going on 26 now, ma'am. That's
sir,
years.
Sir,
that's years.
At the time of this incident, that had been 6 years. So
right, 6 years since I had a violent outburst.
Excuse me. That was aggravated assault resulting in serious bodily injury. Was that were you in custody during that offense?
Was I in custody during that offense?
Yes.
Ma'am, even on that case, there was never no evidence presented. I pled out because I was in prison for 3.5 years fighting the case already. So it just made more sense to go home, right? Take the deal that was offered to me and go home. And that was one of the cases on the deal. Ma'am, I didn't get caught on this crime at the scene. I got caught on, they reported this crime 2 months after this alleged crime happened. Ma'am, you're speaking on something you do not have the facts to, ma'am. You do not have the facts to these things. So you're still you're trying to justify in your head why you want to give me incarceration, which is not in the interest of justice to incarcerate me, because there are mitigating factors to this case that you are not even taking into consideration, ma'am. You're not. All you have said since you said something to me is about, oh, he's this, he's a menace to society. Ma'am, I did not go, this was not random. I was a working father at work who was denied his food because the color of my skin, and it was noted in the phone call that he made to dispatch, if you'd have heard that phone call, when he said it's a black and he threatened my life. Come quick. And I never once, in fact, threatened this man's life. In fact, ma'am, I asked him multiple times to take his hands off me before I even touched him, ma'am. Before I touched him, I asked him multiple times to take his hands off me. I informed him he was committing assault by putting his hands on me. Unwanted touching of any person is assault. Assault does not have the right to put his hands on me, no matter what you say.
Mr. Houck.
Yes, ma'am.
You entered a plea.
Are you justifying that he has the right to put his hands on me, ma'am?
Sir.
He has that right? Can you clarify this for me before I have it on record, please?
Listen, that matter is not before the court for this court to make a determination.
This is what you're damning me off of.
Excuse me.
You're, ma'am, I'm sorry. Give me the time you're going to give me, ma'am, but I cannot sit here and let you lie on me.
All right. I'll answer the question for you. No, he doesn't have the right to put his hands on you if that's what happened. But you walked behind the counter, and then if he grabbed you, I mean, at that point, he doesn't know what you're doing. If he put his hands on you because you went somewhere you're not supposed to be, I think that's justified. I don't know. I'm not a lawyer, and I'm not, but I would say, hey, if you walk behind the counter, angry, and I, try to push you back, I don't think I'm going to be charged with assault. I think you're going to be charged with trespassing. I think that's how it's going to go. And then you hit me. Yeah, no, I don't think I'm going to get in trouble for that. That's just in my head. I think that's how it works. I don't know. Again, not a lawyer.
And condemn me in your head as like this violent individual, and I'm not, man. I'm not. I'm trying to change, and you're not even giving me the opportunity to change.
Interrupting this court. Stop interrupting this court right now. Stop interrupting the court. This court has the information that it was provided after an interview was conducted between one of the probation officers and Mr. Houck.
He's got a good, I'm going to guess that's a lady. I guess it could be a guy. I don't know. But whoever's sitting next to him in the car is trying to calm him down. Like that's absolutely what should be going on. Like, he needs to take a breath. He's going to get in a lot more trouble.
This court also has the criminal history of Mr. Houck and the statements of Mr. Houck, as well as the copies of the police report and statements of individuals at that time. Since there was not a trial in this matter, this court doesn't have the any additional evidence that may or may not have been introduced at trial, such as any body cam, any videos that may or may not exist or whatnot. And so this court is basing its ruling in its order for sentence on what it's previously stated on the record. Specifically, the information this court has as far as what occurred in this matter, again, based upon the reports and reviewing the statements of both Mr. Houck and the victim in this matter, and I think there was an additional individual that was named as a victim, but then indicated it was because they were trying to separate the individuals. This court's not making a determination as to who put their hands on who first. This court hasn't heard any testimony regarding that. All this court's doing is going based on the plea that was put on the record and the facts that this court has before it. Therefore, the court is going to, as I've stated before, the court does not find that there's reasonable grounds to depart on MCL 769.5. The court does not find that probation will be beneficial to Mr. Houck. The court also is taking into account that Mr. Houck is currently on parole for a matter, as well as currently out on bond in another matter out of the Lansing Circuit Court, Ingham County Circuit Court. And therefore, the court does not find that there would be any suitable rehabilitative condition for Mr. Hauk to participate in probation on. Therefore, this court's going to order $45 days jail, credit for 1 day.
Ma'am, can I ask something real quick, please? As far as the credit timing goes?
You had 1 day credit, sir, for the day you were incarcerated and bond was posted.
Yes, ma'am. Can I just ask you something? If not, it's okay. I keep my mouth shut if not, ma'am.
What's your question regarding your credit for time served, sir?
I also did 14 days in jail on this incident too, but that was through my PO.
That was for what?
That was through my PO. I went and turned myself in after this incident and did 14 days also through my
You say
PO.
PO.
Your parole officer?
Yes, sir. Yes, ma'am.
Okay, so that's on that matter. So there's not, I'm not affording any credit for time served on this matter.
All right. It was due to this matter. That's why I was wondering.
I understand that, but that was
I was not-
MPOC, that was as a parole violation, so the court's not.
So that was a parole violation then?
Yeah, I did get violated for this incident and the other incident. I've done 14 days on both of the incidents I caught. In 3 years, I've only gotten in trouble twice, which is an outstanding job for most people on parole.
Okay,
I wasn't aware.
so
For all the lawyers in the chat, if you're on parole and you commit a crime, so this guy got violated for his parole and did 2 weeks in jail, is that considered separate from this? I can see it going both ways. That's why I'm asking the question. I really don't know. Yeah, I don't know if that counts towards this case because it's technically he's doing jail time for the parole, right? I don't know. Hopefully there's someone that can answer that for me.
all right, that's okay. The court's going to do the 1 day credit for time served, and the court's also going to order restitution if requested. As of this point, it does not seem to have been requested, but there may be a request, I'm not
And then if
sure.
he has a right to, we can have a hearing on that. I
Of course.
understand. No, I understand.
All right, as relates to your date to report, sir, the court will give you until Friday to report. So you need to email into Ms. Shine so she can give you the information regarding that report date and how to report and when to
I
report.
believe this is Ms. Short.
I mean, Ms. Shine, did I say short?
No, you did say Shine, but I believe this is Ms. Shaw.
Oh, Ms. Shaw, okay, either one, in the probation. And then also as it relates to your medical marijuana card, you have something in here from a cannabis doctor, it appears, but not from a treating physician. And then the question I had was because it says that you didn't have any, you were not under a doctor's care, you're not taking any medication at this time. Given that this court's not placing you on probation, the court doesn't.
45 days. 45 days credit for 1 day served. Oh no. My power just flickered. Hopefully you guys can still hear me. I don't know if that just shut my internet off or not. But yeah. Yeah, let's get through the stream. I don't know what's going on with the power.
Find a need to continue to address that issue.
Thank you, Ron.
Is that it?
Just make sure you email to Ms. Shaw.
Okay.
Good
So
luck.
I'm done now, though?
Ms. Shine?
Yes, you're all set.
Okay, and what time on Friday? Because my fiance doesn't get off work till like 6 on Friday.
Okay, well, that's why I'm having you email Ms. Shine, email her by 12:45, and she'll communicate all that with you. Okay, sir?
Okay, and then so I'm done, right? Judgment is sentenced and passed down, right?
That's
Yes,
correct.
and if you want to appeal it, you certainly have a right to appeal it.
Well, at this point, I'd just like to say that your fucking court is a joke, and you are carrying your fucking self.
Sir, you are on the
Still in
record,
court, so
and this is a court of law, and that's not acceptable.
good luck.
All right, we're on the record in the matter of Devon Cole, 23218.
I haven't talked, I just.
Oh, you're not spoken, okay, all right, let's go.
Yeah. All she did was say that's unacceptable and kicked him out. How did she not hold him in contempt for that? I didn't hear her say contempt. Did you guys hear her say contempt? All I heard her say was it was unacceptable. My power keeps flickering, guys. I do not think I'm gonna be able to make it through this stream. I've got like 3 really short cases left, so yeah, let's hope I can get through it. But yeah, it I don't know how my internet hasn't shut off. If power goes completely off and comes back on, yeah. Anyways, I'm rambling. I'm gonna stop rambling. Let's watch some videos. Damon, thank you so much for the late fee. I appreciate it. Hopefully you're having a great night. Okay, let's go.
File 24-6800FH for a probation violation hearing. Mr. Koontz is present in the courtroom with his lawyer, Ms. Elliott, and Ms. Goodrich for the people. Ms. Elliott, do you know how Mr. Koontz wishes to proceed today?
Well, Your Honor, Mr. Koontz right now has a pretrial scheduled in Schoolcraft County on September 2nd. I tried to make contact with his attorney there, and we have not been able to speak to one another, so I could see what's going on there. Mr. Koontz reports that he believes there's a plea offer and that he may be entering a plea on September 2nd, but he wasn't super clear. So I would be asking for an adjournment so that we can see what transpires in Schoolcraft County on the 2nd.
And what was the date? That was September 2nd?
Yes.
Okay, Ms. Goodrich, any objection?
No objection.
Could continue this to September 9th then? That'd be fine. We'll put it on September 9th at 10:10 a.m. All right, September 9th at 10:10 a.m. And if you let Miss, we'll set it for probation violation, but if you hearing since he's in custody, but if you please let Ms. Goodrich know whether you intend it to be an evidentiary hearing or not, so she can make witnesses if she needs.
Okay. Would the court entertain allowing reinstating bond? Mr. Koontz has been in jail for 50 days.
All right. This is a really short one, guys, and this is hilarious. This is why we love Judge Gautheir. Just wait to hear his response to this.
For this violation, he does have a full-time job waiting for him in Indian River. He'd be living in Sheboygan County, and I think some bond conditions could secure public safety, any public safety concerns the court might have.
Ms. Goodrich, people's position.
Your Honor, due to the public safety concerns that he was on felony probation for felonious assault at the time that he is being accused of driving while impaired, the people would be concerned.
Yeah, Mr. Koontz, I've got some very bad news for you. You're on probation to me for hitting a road construction worker with your car out of anger. And then while you're on probation for that, you're out there drunk driving. You're not getting out of jail. Not for a long time. So start preparing yourself for that. Motion denied.
And that's it. That's how he does it. Like I don't need a speech. Hope you like jail, man. Like vehicular assault, yeah, and then DUI. Yeah, you're not going anywhere, my friend. Enjoy jail. I just love it when it's that short. Yeah, we don't need to waste any more time on this. Okay, this is another short one. Let's go.
Oh no, is it prosperity?
We're going to reset it for 60 days. I spoke with him. I want to give him some time. He said he's been working on it.
We reset, did he leave? I think we did reset.
He might have left.
Okay.
It might have been reset.
I think that was reset.
Kind of
Okay, sounds good.
pretty firm 60 days that if he doesn't get.
Okay, I don't see another public defender, so if you wanna go and log in to meet with Miss Sina, and I'll take care of some
Put me in a
civil
regular
matters.
room. I should be.
Very good. Mr. Smith? Did he leave?
Yeah, he said he had matters with Judge Ward. He said he was gonna.
What was he doing with Mr. Stitt? Do we know?
He said that he refused to answer questions, and he said that he wants an attorney. He said if we can set it to schedule it in person.
This is the matter of Lansing Automakers versus DeQuan Stitt, 11-02391. Mr. Stitt, are you there?
Yes, ma'am.
Okay, Mr. Stitt, my understanding is that you did go into a private meeting room with Mr. Smith, who represents the Lansing Automakers. This was for a discovery hearing, also known as a creditor or debtor's examination, and that you refused to answer any questions. Is that accurate, sir?
I didn't know who he didn't he didn't say who he was or why he was asking these questions. I didn't know. I don't know what's going on. I just showed up to court.
Okay. That makes sense.
So
If you don't know who's asking you questions, I wouldn't give financial information either. So this is a creditor. This is a credit or debtor's examine. You owe LAFQ some money, and they're trying to figure out how they're going to get it.
Yeah, I'm trying to figure out how much money and some other stuff too, because some other stuff went on. I'm just trying to figure out how much. I don't know how much they sold my car for, because they sold it and didn't really tell me anything after that, because I tried to pay the bill, and then they sold my car, and then for some ridiculous.
You can contact the clerk's office and get a copy of the judgment.
Okay.
And that should tell you what the judgment amount is for. However, because this is set for an official court proceeding to discover information as to how to procure payment on a debt, I'm going to reset this matter. You'll be required to come in person this time, okay?
Okay, what difference is that going to make?
What do you mean, what difference is it going to make?
What difference does it make if I show up to court and then on Zoom?
Because you're going to handle it in front of the judge this time.
I'm in front of the judge now.
Give me a court date.
September 9th at 2.
September 9th at 10? At 2, in person at the court.
That don't make sense. Oh, well.
Yeah, well, it may not make sense to you. It makes sense to the court and to the process. You can appear in person.
I bet it do.
If you don't,
makes
bench warrant
sense.
issue. If you don't, a bench warrant will issue.
Okay, I'll be there. I'll be there.
Thank you. You have a good one.
Still makes sense. That's stupid.
What's stupid is to go back and forth in the courtroom. That's stupid.
All right, that was that one. What's stupid is to go back and forth in the courtroom. All right, I have one more. I have a turtle clip for everyone tonight. This is actually the end of the video, but I found one clip way late. And I already compiled this video for tonight, so I didn't add it to it. But because this is a shorter video, I did make it separate. And since you guys have been on your best behavior tonight, I'll play a little turtle clip tonight. But first, Dilf Bag for 2 months. Thank you so much. Good to see you. Hopefully you're well. And a super chat. 2 months and a super chat. Thank you. Everyone hit that like button for your boy. Yes, please. Yes, please hit that like button. Hit that like button. All right. Also, Katie Zed, good to see you. I brought your comment up and meant to pause it, but there was only like 30 seconds left in the hearing, so I wanted to let it play out. But Katie Zed, good to see you. All right. Turtle clip. If my power goes out and we don't get through this, I'll just put it out tomorrow. But let's go.
For 109, Mark R. Gonzalez versus Stephen Roan.
For the Turtles. Thank you, Legal Fiction, for the super chat. For the Turtles. I don't even remember why we call them turtle clips. Oh, I remember. Because there was actually there was because when I make polls, I always add a stupid answer. That's what it was. And I put something about turtles, and now they turn into turtle clips. Okay, let's go.
Uh-huh.
Mark Dobbs.
Okay. How much is the monthly rent?
Steven didn't have a monthly rent. He was an employee. He came in as an employee and I laid him off and he has refused to leave. Since then, I've given him a courtesy time to stay for 2 weeks, and if he still surpassed that, since then I did add a daily fee of $150 starting at the beginning of the month. And that, I guess we're on day 12.
Mr. Roan?
Good morning, Judge.
Good morning. So have you overstayed your welcome?
Not from my understanding, Judge, and I did have a rent of $880 a month. And
Where does the lease, does your lease?
it was all verbal.
Okay. Have you paid anything?
Not since the 13th or 17th or whatever, when I got terminated. And then if you look at the notice,
The 13th of July
I think, let me look.
is when you got terminated?
The 15th, I'm sorry.
The 15th of July you were terminated?
Yes.
Okay.
And then that notice gave me until July 29th to leave the premises.
Okay.
And from what I understand, he went ahead and
Is it storming really bad there too? This storm just kind of came out of nowhere. Like absolutely out of nowhere.
went around that notice and filed the next day with the courts without allowing the notice to expire. And for what I've done, the small amount of research I've done, he has to allow that notice to expire before he can file an eviction with the courts.
And do you have anything in writing or
I have a bunch of his things. This is just what he gave me.
does it say that you have 2 weeks or?
Yeah, it has a date on here. I think, let's see, this is the first one, and this is the one that's the daily fees.
Your Honor, you should have those documents, Your Honor. The notice of termination.
You know the rule. Whoa. Right when I paused it, a huge strike of lightning just went across my window. But you know the rule. Instant pause for 12 months. 1 year pair. I think am I getting that right? I think I'm consistently getting that right now. Thank you so much. I do appreciate it. 1 year. That is awesome. Thank you.
And notice to vacate, that was given to him by hand on the 15th. Also, when I handed that to him, I also made it clear to him that I needed for him to be clear of the area because I had business that I operate through there. And in doing so, I told him that I would have another place that he could he could park during the day. And the very following day, he was still there after 7 o'clock, after passing that time. Once he passed that time, the police officer, I wasn't aware that I was dealing with somebody that wasn't going to want to leave.
Oh, I'm sorry.
When
This
we
one.
had verbal agreement that he was going to leave.
This is the one she didn't have.
13th, we had a verbal agreement that he was going to leave. I even gave him I gave him $1,000, which wasn't pay. It wasn't extra pay for doing a good job. It was just $1,000 as goodwill for myself to send him off in a good way. And
I'm in Ohio.
he still, by the 14th, when I asked him like, hey, what's your plan? What are you doing? He got aggressive with me.
It does say, let me stop you there. It says you are being provided a 14-day written notice to vacate. So he did have till the 29th to vacate. So why'd you file the next day if you gave him 14 days?
Well, 2 reasons. One,
because it shows that you filed on the 16th.
Yes, ma'am. Yes, ma'am. I filed on the 16th because on the 16th, he was still there on the property at 7 o'clock during the time. And he had actually caused some trouble with me there with the police officer. And
29.
When I came to visit the courts, they told me that the time was so far out. They told me it was a month out from when I come to do the proceeds. He also has a text message that he submitted as evidence. And I'll say that that text message shows there that it says that if he was gone by the given time, that I would dismiss this. He has not been gone since the given time. He is still there. That's why we're still here, man. I'm just looking for possession. I'm looking for Stephen to leave and for us to take possession. I've given him more than
So you
enough.
were supposed to leave on the 29th.
All right. So this guy used to work for the landlord. So this is a landlord tenant situation, but not really. It's more of an employer employee situation. The tenant worked for him, so there's no lease. Like you're working here, you're working for me. It's like what is that called when you get? There's a term for it when you get housing through your job. I can't employment housing maybe. But yeah, and the employer even gave him $1,000. Like here's $1,000. Go leave, and he's not leaving. So good job. Way to be a jerk. I wonder what he. Yeah. Anyways, I'm gonna catch up on these. Do real quick. Katie Zed for 2 months. I like turtles. I like turtles. I like turtles. Thank you, Katie Zed. Miss Orchid Blooms for 11 months. Thank you. Dorina coming in at 18. Following Jedi at 19. Thank you guys so much. I do appreciate all the membership milestones. And then Jen for $5. Thank you. Judge Webster's glasses will overrule Judge Brown's glasses. Yeah, I think Judge Webster has her. Because I've only ever seen Judge Brown wear that one pair. Judge Webster has about 20 different pairs. So I think Judge Webster would win on that alone. But I agree. Thank you guys.
I know he filed on the 16th, but you still didn't leave on the 29th, and you've had 14 days. You've had 14 days since the 29th to leave. That's
So our original agreement had nothing to do with like getting out within 2 weeks of me being terminated from a contract job.
You still are not gone, right? And it's been a month since you were terminated, and you're still not gone.
Yeah, you could say that. But he did try to.
Looking at my calendar.
Yeah, those dates line up perfectly well, but he didn't allow the notice to expire before he went and filed with the state, and that's what the law requires. If he gave me a 14-day notice, he has to wait until the 14-day notice expires before he can file with the court.
I understand, but you're still
Now, he
not gone.
violated, on the 16th, he violated, and I gave him an immediate violation, I submitted to him an immediate notice to vacate due to violation of terms.
Okay, where is that? I want to see that.
You should have that
Well,
one.
let me have it, so I can just see it.
Submitted that one, and I had a witness when I submitted that one to him as well.
So I wasn't
Okay.
understanding that he could deprive me of my rights to stay there during the day.
He never had rights. It was a privilege for him to stay there. I allowed it because he was an employee and I was trying to be good to my employees, send them off in a good manner. Mr. Steven hasn't left. He's still making it difficult for
He
us.
still owes me money.
I don't know what you want to do.
Okay, that's for another day. It looks like he paid you $1,000 over and above what he
Yes, ma'am.
owed you, and you're still on his premises. And he did give you this notice to vacate right here on the next day because you were not gone at 7 a.m. in the morning when he does operations. I guess your truck is in the way.
Yeah, it sounds.
So it looks like,
No, ma'am, that's not true.
well,
I'm not in the way whatsoever.
go ahead with the eviction because he did give you this notice.
On the 30th, after I spoke with him after the 29th,
Mhm.
he made it clear he wasn't gonna leave, that 2 weeks wasn't enough. So I gave him another notice that if he continued to stay there, it would be an additional $150 a day for his stay. And Mr. Steven is still there.
And that's on the July 31st. So you gave him a notice on the 16th. You gave him a notice that one was on the 31st. He's given you ample notice.
Yes,
You've paid
excuse me, ma'am.
nothing. I'm gonna go ahead with the judgment. I'm sorry.
Well, if you look at the subsection of the law,
Okay, you can appeal, but I'm going forward with the judgment. How much would a property and that,
so he
like
can
a fair
deprive me
market,
of my
sir?
rights to stay there during the day,
I'm
when I'm normally staying there during the day.
Can you please take him out? I already told you what my judgment is. How much would a fair market rent be for that place?
We wouldn't really rent it out. It's more of an office space, and I looked at it. If we were to do like an Airbnb style, it would be about $150 a day. Anywhere from $120 to $150 a day. The other thing, ma'am, if you could see the way Mr. Steven is, I would like to see if I could get a protective order when he does the property.
We don't do protective orders here. You'd have to go through the DA's office. But I will have a constable walk you out.
Yes,
A
please.
deputy walk you out for sure. So it's about $3,600 a month?
Well, well, even if we did it less, Your Honor, it's something you could decide. For me, that is about what it would be. We would do it in Airbnb style. It's not for rent. It's on a 12-acre property. It's an oasis. It's nice. Yeah.
Okay. I'm gonna do, that it's 3,000 a month.
Whatever you decide, ma'am, will be fine. We're more seeking possession.
Yes. So
Yeah, they are. We are blessed with two great theme parks. Not theme parks. That's not a theme park. What is it? What are they called? Anyways, they're awesome. Kings Island and Cedar Point are awesome. And yeah, if you like roller coasters, I haven't been on a roller coaster in probably 10 years, but I absolutely love them. They're great, and I'm spoiled. I'm absolutely spoiled for being in Ohio. I will say this though. When you said that I lived in the coaster capital of the world, I was thinking a drink coaster. I was like, I don't know. Is Ohio the shape of a coaster? I mean, maybe. I don't. I didn't understand it until your next comment about Kings Island and Cedar Point. But absolutely. But thank you for this. Thank you for the super chat. I do appreciate it. That being said, amusement park. Thank you. Thank you. I couldn't get theme park out of my head. I could not get theme park out of my head. Yeah, amusement park. Okay. I'm going to let the rest of this video play out. There's only about 30 seconds left. And now that I paused it, I will just let it go. So, guys, thank you so much for watching me tonight. I do appreciate it. Thank you for the super chats, the gifted memberships, the membership milestones. You guys are awesome. Very generous tonight. And as always, thank you, mods. You guys are awesome. And that's it. That's all I got. I'm going to go look for someone to raid. It is Tuesday night. Katie Zed's here, so they're not doing a random booze and body cam on a Tuesday night. So we're probably going to raid Lone Wolf, especially since KCC raided already. So yeah, I'm going to guess that that's where we're going. If we're going anywhere else besides Lone Wolf, I will pause it at the end and let you guys know where we're going. But that's probably where we're going. You guys have a great rest of your night. I will see you tomorrow. Until next time, bye.
Just have to set an appeal bond. So that's what I need to do. So the judgment is for the plaintiff in court cost, post-judgment interest, and possession, setting the appeal bond at $6,000, and he does have 5 days to appeal, just like I told him. Okay? Good luck to you. Can someone walk him out, please? Yeah, I only have 3.
Oh, that's it. I gotta bring this back up. All right, now I'm actually saying bye. Okay, bye.